Hello, I'm Evan Wright from J&W Solicitors. It is July 2020 and hundreds of suspected criminals have just been arrested following reports that the secret communication system used by a lot of criminals has been compromised. It relates to the use of Encro phones. So what are encrypted phones and are they legal? Encrypted phones or Encro phones are widely regarded as one of the default communication methods for organised crime groups, but celebrities use them, the military use them, as do persons dealing with highly sensitive commercial communications. But they're available for anyone requiring encrypted communications. Up until now, the phones have been completely secure and anonymous. Possession or use of the Encro device is not an offence, but it can of course be used in a manner giving rise to criminal offences. Now, bear in mind that it can also be a criminal offence under Section 53 of the Regulation of Investigatory Powers Act 2002, or REPA, for a suspect to fail to disclose a password or code when they are served with a Section 49 notice. News outlets now say that EncroChat, who host some of the devices, have had their domain hacked by government entities. This was followed by a wave of arrests and seizures across organised crime groups. The UK's National Crime Agency don't usually confirm or deny their involvement in operations, but they're normally the agency tasked with operations of this type. So can suspects challenge Encro evidence? The starting point is, was the evidence obtained lawfully? Were the seizures lawful? And were the resulting arrests lawful? If not, should the evidence obtained from those investigations be admissible in criminal proceedings? Section 78 of the Police and Criminal Evidence Act 1984, or PACE, is relevant. The court may refuse to allow evidence on which the prosecution proposes to rely to be given if it appears to the court that, having regard to all the circumstances, including the circumstances in which the evidence was obtained, the admission of the evidence would have such an adverse effect on the fairness of the proceedings that the court ought not to admit the evidence. So it follows that any suspect in an Encro investigation should investigate the circumstances and lawfulness of the hack, and that will require some very specialist technical input, which thankfully we have. Separately, if evidence was obtained illegally via the hack, it could be considered as intercept evidence, which under Section 56 of the Investigatory Powers Act 2016 can't be used in criminal trial, save for circumstances relevant to the Schedule 3 exceptions and limitations. The European Convention on Human Rights might be engaged in that an accused may argue a serious breach of those rights and protections. That will depend upon a number of factors, not simply an apparent breach. Quite apart from the technical, legal or forensic challenge, there may be more practical considerations. Arrests will have been made based upon inferences drawn from the data found in the communications. Have those messages been properly attributed to the individuals? How are the phones themselves connected to a particular suspect? What is the evidential connection between the data and the application for a search warrant at a particular premises? In other words, were the search warrants lawful? Have the messages been interpreted in such a way as to infer criminality and justify arrest when a reasonable and lawful interpretation is equally possible? So there are potential legal, technical, practical challenges. Timing is very important, because when the prosecution stone starts rolling, even the best points can fail to stop that stone if they are late. So feel free to get in touch if you need more information. I'm Evan Wright, and thank you for watching.